Oh, this is a bit of annoying. How do I escape? Oh, there we go.
And Aswini, you're going to do the intro, yes? So I'm going to turn my camera off and mute.
I'll do the intro.
Right, she's going to do the same.
Okay.
Right.
How will we know when we're live?
So I'm going to hit broadcast and you will see the participants bar fill up. Can you see the
Great.
Yeah?
Cool.
Oh, here you go, you're live.
Thank you.
Hello. Well, welcome everyone. Sorry we're a few moments late joining this afternoon, but thank you very much for joining us. I've just got to give you a few housekeeping bits of information before we get started fully. So for those of you who are new to Zoom, I have to tell you that we have muted your mics, and you'll notice that, and your videos are also off, and that is a presetting, so don't be alarmed. It just stops any background interference. There's a Q&A function, and we're asking you to use this rather than raise your hand today, and we will try and deal with as many of your Q&As as possible if we have the time, or we will respond by email post after the webinar. The session is being recorded, so you'll be able to get a copy of the recording and also the slides after the webinar, assuming that that's what you would like to have. So with that, I will get started. Can I have the next slide, please? Sean, slide.
I think we've got. So we've got that.
Oh, we've got slide. Sorry,
yes,
I'm looking at the wrong slide. Apologies for that. My technical prowess demonstrating its complete woefulness. So Sophie and I are speaking today, obviously, and this is what we're proposing to cover today. Sophie will go through the temporary changes to the Mental Health Act, and I will touch on some of the convention issues arising from those changes, and then we will both look at aspects of psychiatric detention during the pandemic. Thank you. Next. So the aim of the talk, as in other areas, you will have found that there's a proliferation of pandemic guidance, not all of which has been useful or detailed from a practical point of view. We're all having to reach for different sources of information. So what we're hoping to do today is take some of this burden off your shoulders. So over to Sophie.
Thank you very much. So as Aswini's explained, the context of the changes in the Coronavirus Act are temporary, and they are aimed at freeing up clinical staff wherever is possible. And the key changes that I've dealt with on this slide are about the procedures for applications to people to hospital under either Section 2 or Section 3 of the Mental Health Act. And Section 2, of course, is for people to be detained for assessment or assessment followed by treatment up to 28 days, and Section 3 can be for longer, up to 6 months, and that's for treatment. And at present, you need 2 medical recommendations to be detained under either of those sections, and the application's made by an approved mental health practitioner. So the provision in Schedule 8 of the Coronavirus Act changes that. Instead, you only need 1 medical practitioner. That medical practitioner has to be approved under Section 12 of the Mental Health Act, but needn't have any previous acquaintance with the patient who's going to be detained. Now, at present, that's a change, because at present, the requirement is that if possible, if practicable, one of the practitioners who makes the recommendation should have previous knowledge of the person who's likely to be detained. The approved mental health professional can decide to proceed with only 1 medical recommendation, and the test is whether waiting is impractical or whether it would cause undesirable delay. That's a phrase we're going to see again and again, and it's very pragmatic, and I think it's very much a low threshold. There's no change to the criteria that the practitioner and the approved mental health professional are considering, and there's no change to the time limits. So moving on to the next set of provisions, we've got a set of changes to the arrangements for people who are already in hospital, but they're being treated informally. At present, they could be detained under Section 5(2), and this Section 5 allows holding powers by doctors and nurses. At the moment, Section 5(2) is exercisable by the practitioner, the medical practitioner or clinician who's in charge of the patient's treatment. And if that person thinks that the patient ought to be detained, they can make an application, they can furnish a report to the managers, and they can detain that person for up to 72 hours. Now, at present, with the new changes, if they come into force, any practitioner or clinician can make that decision and can then hold the person for 120 hours. So that's double the time. Section 5 also provides for what's called a nurse's holding power. That's at the moment exercisable by a nurse who's registered in mental health or learning disability nursing. And the criteria for that power is if the nurse thinks that the degree of the person's disorder is such that it's necessary for them to be immediately restrained from leaving. At present, they can be detained for 6 hours, and that's going to change so that it will then be 12 hours. So the next set of provisions deal with people who are coming into hospital through the criminal justice system. And if we can just move on to the next slide, please. Here we go. This gives us a set of changes to the arrangements for people coming into hospital through the criminal justice system. Perhaps the one that causes most concern is the first one. That's at paragraph 5 of Schedule 8. And that deals with people who are being remanded to hospital, either for a report or for treatment. And at present, there is a time limit for that. Paragraph 5 will remove the time limit on remands to hospital. So potentially a court could remand someone to hospital for treatment or for a report. And now, if the amendments come into force, the control of the timescale will be completely with the court. So paragraph 6 then deals with the situation where someone is being remanded for hospital for treatment, or the court is being deciding to order detention, hospital or guardianship. At present, under paragraph, all of those powers require 2 medical recommendations, and as you see, as we've set out on the slide, A to E, now only 1 recommendation is going to be required. And the same goes for the power of the Secretary of State to transfer a patient from prison to hospital. Only 1 practitioner is going to be needed, and we're back to the same criteria if 2 reports are impractical or if they'd cause unnecessary delay. So we're now going to move on to and look at the provisions in paragraph 8, and this really deals with the time limits on conveyance or admission to hospital of patients who are coming into hospital by orders of the court or being transferred from prison. And as you can see from the slide, at present there is a strict time limit as to when those people have to be admitted to hospital. And what these provisions essentially do is just give everyone a bit of wiggle room. It means that it extends that time limit to as soon as reasonably practicable, with a backstop of 7 days after the time limit. So it just gives everyone a little bit more time, recognises that things won't necessarily be able to be done at exactly the time that was anticipated. So moving on now, we're going to look at some of the perhaps the slightly more controversial changes. At present, one of the current safeguards for consent to treatment under the Mental Health Act is requirement for a second opinion to be arranged by a doctor, carried out by a doctor when these arrangements are made by the Care Quality Commission. And that has to take place before medication can be administered to somebody without their agreement after they've been in hospital for 3 months. Now, that requirement is now gone. Essentially, what will now happen if the changes are brought into force is that the clinician in charge of the patient's care will really self-certify. What is left of the safeguard is that they will have to consult with someone who's concerned with the patient's treatment, and that's someone who comes from a non-medical background. Now, if we can just move on and have a look at some statistics, we can see now that the Care Quality Commission currently gets about 16,000 requests for these sorts of second opinions. And I was interested to see that in 29% of cases, they actually change the treatment plan. You can see the source of that, the Monitoring the Mental Health Act report. Now, obviously, we don't know how they changed the treatment plans, but clearly they certainly aren't rubber stamping the plans that they're being asked to look at. And I think it's also important to consider the recommendations of the Independent Review of the Mental Health Act. I've put on the slide one of the quotes from the review. Not being able to make choices about the treatment obviously is a huge issue to people who were spoken to during the course of the review. And in fact, the direction of travel of the Mental Health Act review is to try and make it harder for clinicians to administer treatment against consent. So really this is going against the direction of travel of the government's report. And I would very much hope that this is not a provision that's going to become the new normal. The next set of provisions we're going to look at relate to changes to emergency powers. So these are the powers under sections 135 or 136 to detain someone in a place of safety. At the moment, the time limit for the place of safety is 24 hours. Now, this has been increased now to 36 hours. And that's quite interesting because many of you will remember that the until amendments made by the Policing and Crime Act 2017, the time limit was actually 72 hours. And there was quite a lot of concern that that was really too long. And we can see here that the government has resisted perhaps what might have been an understandable temptation to go back to that limit. The next set of provisions deal with changes to the Mental Health Review Tribunal in Wales. And the reason that these have to be dealt with through the legislation is that they don't have the ability to make practice directions through the first tier tribunal in the way that the English tribunal is able to operate. We'll be looking at the overall impact of the tribunal and the changes in England in a minute. But there's a couple of changes that are quite important for those practicing in Wales. Paragraph 11 allows the president of the tribunal in Wales to permit hearings to take place with just one legal member, possibly one of the non-legal members as well, but certainly not the usual 3 members. And again, the criteria for deciding to do that, that it will be impracticable or would involve undesirable delay for the tribunal to sit with 3 members. So as we're going to see, there's a very similar process going on in England. The next provision, though, that we will see in a moment, at paragraph 12, allows the Mental Health Review Tribunal for Wales to determine an application without a hearing if 3 criteria are satisfied, and I've set them out on the slide there. If the tribunal thinks that those criteria are met, then they will give a provisional decision to the parties that they intend to deal with the application without a hearing, and they can reverse that on receiving representations. And I think that is perhaps somewhat troubling, because that really puts the burden on the patient to explain why they should have an oral hearing. So I think that if those changes do come into force, I think it's going to need really careful monitoring, and it will be very interesting to see how those powers are eventually used. So that gives us a summary of the provisions. And what we're going to be looking at the moment is the position paper prepared by the Royal College of Nursing at the time of the coronavirus bill. And I thought it would be interesting to look at that. You can see they have quite a creative idea that because of the civil liberties implications of these provisions, the government should review Schedule 8 with the chair and the members of the independent review of the Mental Health Act, 3 months after their changes are brought into force. They also suggest extending the range of professionals who can become approved mental health professionals. And the next slide that we're going to look at is some legal guidance from NHS England, which is quite important. I've given you the reference where you can find it, and some quite important comments here that we see that the guidance is explaining. So wherever possible, we must continue to guard against overly restrictive practice. Even if Schedule 8 is enacted, it should only be used locally when absolutely necessary, and under no circumstances should the Act be used to enforce restrictions that aren't related to mental health. We've got a little bit more from that guidance in a moment. If I can we can just have the next slide, please. So just looking at the first tier tribunal mental health. So these are the arrangements for the tribunal in England. The pilot practice direction issued on the 19th of March, and essentially that's changing the composition. Judges are sitting alone in all cases. There can be a full panel if it's considered appropriate. And I think we're becoming aware of some cases where applications have been made for a full panel and haven't always been approved. But even if there's a judge sitting on their own, they're able to seek advice from wing members. That advice has to be recorded as part of the decision. And in some cases, it says that CTO references are going to be dealt with on the papers by agreement. But as we'll see from the next slide, which is some user information, the tribunal explains that they're prioritising Section 2 and recall hearings, that the intention is to conduct all hearings by telephone. They've now moved to a video facility. And if the patient's unrepresented, it's suggested that they might be given an opportunity to speak to the judge without other people being present in the room. And we can see that, in fact, things have moved on from there as well. If we move on to the next document, which is the Help for Users document, and you can see there that, in fact, what the tribunal is saying is, well, we're just not going to be able to deal with CTO cases because of the difficulties in capacity in making sure that they've got enough people to cover all the hearings. I'm going to just deal with a couple of points in relation to the upper tribunal. The upper tribunal, again, has done a practice direction. We'll usually be making decisions on the papers where the rules allow, and we'll invite the parties' views to that. And again, hearings are going to be taken remotely. And then finally, from me, before I hand over to Aswini to look at the implications of this, we've got a little bit more about the upper tribunal on the next slide, if I can have that one. Guidance for users just explains that arrangements are in hand for processing applications, and they also say that they may need to prioritise cases that are linked to welfare benefits or other important rights, and I would anticipate that that would include MHA cases. So thank you. I'm just going to hand back now to Aswini to look at the convention implications of all of this.
Thank you, Sophie. And so it's back to me. And so I've picked up these 4 themes for the convention issues: medical recommendations, no SOAD, tribunal constitution, extended periods. These are essentially the 4 areas of temporary change under the Mental Health Act. So on the next slide, dealing with medical recommendation, this takes us right back to the seminal case of Winterwerp and the Netherlands, which sets out the 3 minimum conditions for lawful detention under Article 5(1)(e) of the Convention. So we're looking at A, reliably shown to be of unsound mind; B, mental disorder of a kind or degree warranting compulsory confinement; and C, continued detention depends on the persistence of such a disorder. But we're really concerned here with the first 2. So what Convention says is that you need a true mental disorder reliably shown by objective medical expertise. And on the next slide, I've set out the domestic law. The Court of Appeal has adopted the Winterwerp formulation in its entirety. And you can see really that there's no requirement in any of the case law for more than 1 medical recommendation, and no suggestion that objective medical expertise can only be founded on needs more than one medical recommendation. And just to highlight that, of course, there are other safeguards still unchanged within the Mental Health Act in terms of criteria, discharge criteria and safeguards and so forth that Sophie has already, in fact, mentioned. But I will note that the grounds for detention during the pandemic under the Mental Health Act must still link to the mental disorder. So if someone is resisting social distancing, potentially infectious and at a risk of infection to themselves and others, their detention may be more appropriately carried out under the emergency powers of Schedule 21 of the Coronavirus Act, unless the detention is also necessary for treatment for mental disorder. I'm going to say a little bit more about that in a moment. So if we move on to the next slide. So looking then quickly at the second opinion situation, it seems to be more problematic. So criticisms have been made about sections 58 for a very long time, since 1998. You can see there the CPT raised concerns about it, and I've set out in the slide what those concerns are. Sophie's already mentioned that the Mental Health Act review has addressed some of these criticisms, and that these current amendments are in fact rowing backwards from the recommendations of the Mental Health Act review, which is obviously concerning. It certainly leaves patients at risk of long-term medication, side effects and so on. And I would suggest clinicians would be well advised to focus on the wishes of the patients and take steps to encourage patients to comply with medication, and perhaps to self-monitor, that is for the clinicians themselves, through the use of multidisciplinary team working to justify the use of long-term medication. So if I move on to the next slide, looking at the tribunal constitution, I don't think there are any major issues through the reduction to judge-alone hearings. And I've set out here what Article 5.4 requires of the, in quotes, court right there. The move to paper hearings for CTO patients, that's not new, so that's by the consent of the patient in any event. Delays in relation to CTO hearings and postponement of CTO hearings, well, these I don't think will raise quite the same issues as for an inpatient who is detained, and that situation was dealt with in the case of KB, you might recall, related to the award of damages where delays were caused by administrative issues at the tribunal end. But those were detained patients under Article 5.4. And the case of PJ has made it clear that CTO patients are not detained. Issues relating to representation and participation by the patient, I think Sophie's going to deal with later on. So if I move then quickly through the next slide. So I don't think there's anything of note to add here in relation to extended time period. So let's move on then to psychiatric detention during the COVID period. So I've highlighted some numbers here. There are huge numbers of new detentions in the period of 2018 to 2019, and including of elderly people over 65 who are particularly vulnerable, as we know, to COVID infection. The daily government stats are of deaths in hospitals, and checking the Mental Health Trust stats that are provided, there's a strikingly low number of reported deaths, which appears surprising. So for example, Central and Northwest London has a total of 6, East London 17, Slam 2, Southwestern St George's 1, Hillingdon much bigger at 144. As I said, this is surprising because, we heard, surprising, but we heard, I think yesterday you might have picked up on Twitter and elsewhere, of the underreporting of COVID deaths by trusts, which was challenged successfully by the Good Law Project, RIS solicitors and our own Adam Wagner. So maybe that's one reason for it, but certainly something to keep an eye on. The Lancet article that I've set out there highlights an important point, which is about marginalised populations such as those detained in mental health institutions being overlooked. But turn to the next slide, please. The Lancet article also sets out a familiar catalogue of risks faced by people in psychiatric detention, which makes them a highly vulnerable group of people to infection at this time. To the next slide, where I've set out, this is in fact Oliver Lewis's slide. He has written extensively about the need to move people out of congregated care settings such as care homes, and I think obviously it applies in this setting too. We're looking at protecting people's lives where there is a real and immediate risk to their lives, which raises issues under Article 2. So on the next slide, I've set out just what the emergency legislation is and where the current guidance comes from in terms of legislation. You'll be familiar with the social distancing regulations, and second bullet point there covers Schedule 21, which provides emergency powers to isolate potentially infectious or infected people by compulsion. There's a right of appeal to the Magistrates' Court. And Sophie and I will be talking about the detail of these provisions in next week's webinar. But for present purposes, I shall tell you that a PHO is a public health official, and there are public health protection teams that can be called in when compulsion may be needed under this provision. There's no guidance that I could find on when this should be done in this context in mental health units. Although, of course, the Mental Capacity Act, DOL's guidance issued by the Department of Health and Social Care, does make reference to when a consultation with public health teams might be required. I don't know why it doesn't exist in this context. So if we move on, I think what we're really looking at then at this point is inpatient care and how the risk of infection is to be managed for patients who are detained. Again, there's not much detailed government guidance, and I've found more from the Royal College of Psychiatrists and the Royal College of Nurses. And I provided a slide later on which has the URLs linking to all this guidance. And it covers the areas set out in the slide. It doesn't mention policies, that's my addition. Obviously, that's and useful point for lawyers to focus on, the need for new guidance to be set out in policies by each trust. So the government, it's really largely common sense, I should say. There are a number of themes about keeping restrictions to a minimum, involving families, communicating well and in advance if there is to be isolation and so forth, which, you know, is all uncontroversial. The guidance covers the ordinary running of wards and preventing the spread of infection while trying to maintain routine mental health care. So COVID symptoms are prioritised, and national guidance and regulations must be complied with by all. The guidance says that patients should be encouraged to stay in their room if they're symptomatic to self-isolate, and that wards must find creative ways to help them to adjust to this. I think some of it's fairly aspirational. There's no detailed guidance around that. It does say that there may be some disruption to routine mental health care as COVID symptoms take priority. So there might be, for example, postponement of medication reviews, which will be exacerbated by the lack of second opinion certification for long-term medical treatment. So a patient on clozapine will still need blood count testing. What happens there? As for medication, there's an interesting set of guidance there which says that individual plans must reflect the needs for increased physical monitoring when patients are on specific drugs which elevate the risks of infection. So, for example, benzodiazepines, which are used for rapid tranquilization, increase risks, and lithium toxicity can be experienced by febrile patients. So we turn to the next slide, please. More problematic in inpatient settings are patients presenting with challenging behaviours and a risk of infection. The NAPQ has produced very detailed guidance and is heavily reliant on local ethics committees, which is not surprising. It underscores the individualised approach that is necessary. It sets out a framework which it should be read with Chapter 26 of the Code of Practice of the Mental Health Act, and it is to be updated regularly. This is new territory and people are learning as they go along. And on the next slide, what I've done is I've set out what the Mental Health Act Code of Practice Chapter 26 does. It applies whether or not a patient is detained. But realistically, a patient presenting with such disturbed behaviour as to require seclusion and segregation will most likely be detained. And it does require and specifically advocate provider policies to guide services. So the next slide, I've set out the language of the guidance provided by NAPQ. It's the language of chapter 26. That's of primary, secondary, tertiary interventions. So tertiary interventions we probably more usually call positive behaviour support interventions. So the language is of isolation or seclusion or segregation. So there's a distinction to be drawn between challenging yet cooperative patients for whom secondary interventions such as isolation may be needed, and challenging and uncooperative patients for whom segregation is justified. And that brings us back to Schedule 21, which I'll revert to in a moment. As the code advocates, trusts must produce written policies setting out how these interventions are authorised, reviewed, and terminated. So we move to the next slide. Secondary interventions. If isolation is for risk infection only and the patient is cooperative, then the Mental Health Act Code of Protection may not apply, but every effort must be made to apply its principles, which are planned interventions, evidence-based interventions, lawful action in the patient's interests, which are proportionate and dignified. Isolation needs a plan with the cooperation of the patient, reducing physical intervention as far as possible, and maximising well-being. So at this point, it is likely that some advice would have been sought about infection treatment and management. Again, I said there's no guidance that I could find on that. You would expect that the health protection team should be involved to assess if compulsion might be needed to keep a patient in isolation for the assessment or treatment of the infection risk, and not for mental disorder. So at that point, Schedule 21 powers may be appropriate, but there's no guidance on that. And where there are doubts, the ethics committee is again advocated. So turning to tertiary interventions, this is the ultimate stage where the patient is exhibiting disturbed behaviour due to mental disorder, meaning that there's a significant risk of others, to others of infection, and it needs authorising, reviewing, and a good process as advocated in Chapter 26 of the Code of Practice. Medication might be needed in the intervention, and that's provided for in the guidance, and that must be carefully chosen for a COVID positive patient. The use of PPE is discussed, and again, there's obviously new areas in this context, and it goes through what works and what doesn't work. What doesn't work is plastic aprons in a physical restraint that just gets in the way. Scrubs, overalls are what are required. What's available, of course, we don't know. Ethics committees, again, as you can see. So that's a quick trot through that set of guidance. Looking at Section 17 leave, all that guidance does cover Section 17 leave as well. I'm not going to say a great deal about Section 17 leave, other than that it does need an individualised approach for each patient, and that clearly and obviously no blanket policies could be tolerated. Obviously, staff shortages will be a problem, and there might be reductions in leave as a result of that. The RCP guidance oddly suggests that, and quotes, fresh air breaks for smoking should be stopped, and that patients should essentially be forced to give up smoking because the virus attacks lungs. Well, that clearly seems highly unrealistic, and I think it's you just cannot have a blanket policy of that kind, and I'm not sure if there are any trusts who are trying to do that. I certainly haven't come across that yet. So dealing also with Section 17 leave in the next slide, I've just set out there the quote from Hiller in Austria. This was an Article 2 case. Nevertheless, this paradigm is for a detained patient, I think, cannot be compromised, even in this time of pandemic. It goes together with the quote from the UN High Commissioner for Human Rights, Michelle Bachelet, which was in the previous slide. And the added risks of infection and the risks of death in congregated care must mean that Psychiatrists must do everything that they can to lift detention immediately where possible, and where the risks from COVID outweigh the risks associated with the person's mental disorder, clearly discharge must be planned. And coming to the next slide, I've got set out here some sources on ethical considerations for psychiatrists. Of course, the CRPD, everyone will know, eschews any detention on the grounds of mental disorder. This is my final slide. It's on basic action points. But taking one step back from what I put onto the slide, the first question may well be that there are maybe the first question may be, are there grounds for detention, and are they based on COVID or mental disorder? If it's COVID, then it may be necessary to look for the emergency powers under the Coronavirus Act and Schedule 21 for compulsion and not the Mental Health Act. I think I was going to mention, I think I've already covered the issue of no hearings earlier on. Yes, I've done that. So that brings me to the very last slide that I have, which is the resources slide that I mentioned. And with that, I'm going to hand back to Sophie. Thank you very much.
Thank you very much, Aswini. So I'm going to be looking at discharge planning and then looking at the tribunal itself. And the first thing to notice about discharge from detention under the Mental Health Act is that there's been no changes to Section 117, duty under the Mental Health Act to provide aftercare. We know that's a joint duty on the relevant local authority and the clinical commissioning group. Now, we all do know that the Coronavirus Act made some changes to the Care Act, effectively by downgrading some of the duties that currently local authorities are required to do to powers. And if you want to know more about that, I'd recommend having a look at the post that my colleague Mary Rachel McCabe has provided, and I've got the link on the slide there. And also the guidance for local authorities in operating those easements. And of course, there will be some patients who are detained in hospital under the Mental Health Act who aren't entitled to aftercare under Section 117, or may also have needs that are going to be met under the Care Act. So in that situation, the easements may well be relevant. If we look on to the next slide, I've referred to some quite a really important guidance that's been issued by NHS England and NHS Improvement. And it's really worth having a look at that. It's got some very important points in how services, both in inpatient and community settings, should be responding to the pandemic. And you'll see they've mentioned the name for quick decisions. And again, referring to the possible use of patient panels or ethics committees in difficult cases. They've talked about the need to maximise the capacity for digital visits, and that's in relation to home visits as well as assessments in hospital. And then there's a rather cheeky reference to the commitment of the Chancellor of the Exchequer, who has said on many times, whatever the NHS needs, it will get. And therefore the guidance is saying, well, financial constraints shouldn't be standing in the way of action. And that includes discharge packages. And so if we look at the next slide, we'll see a bit of guidance here about how, what is the aim here? And the aim here is to review all inpatients to support safe discharge where possible on a case-by-case assessment. So very much what Aswini's been talking about, it's been encouraged through these pronouncements of these international human rights bodies. The domestic guidance is also saying, if you can safely discharge the patients, please do so. And of course, discharge plans are going to reflect the risks that may arise in relation to the pandemic for particular individuals. So perhaps an obvious example is somebody who is very disinhibited because of the degree of their mental disorder. Are they going to be able to observe social distancing? Are they going to be going up to people, be behaving in a way that's intrusive, perhaps in a way that might just cause a little bit of annoyance in normal times? But is that in fact going to put the person at risk because of the reaction of the other individual who's worried about infection? Two really important points here as well. There's the guidance stresses the need quickly to agree who's responsible for care packages, and maybe to have more frequent meetings of funding panels rather than fewer of them. So if that guidance is being followed, we should see fewer disputes about, well, you know, who's responsible, what are we going to pay for? The tenor of this guidance is get on with that decision making. Think about things like pooling responsibility or having one agency funding the person on a without prejudice basis while final decisions are made about who's responsible. So that, I think, that guidance, I think, is going to be helpful to us. And then next, we're going to be looking at how the guidance approaches the transforming care agenda. And of course, transforming care is a long-running program aimed at getting those people with learning disabilities and or autism who are in hospital or out of hospital, or preventing them from being admitted to hospital in the first place. And of course, one of the tools for trying to achieve that is the requirements to hold care, sometimes care and education and treatment reviews, either when a person's at risk of being admitted to hospital or if they have been admitted to hospital, to see if there's any alternative. And again, I've set out where you can see the main guidance in the second bullet point there. What the managing capacity guidance says is, well, we know we're going to have to do these in a different way, but we still need to hold these reviews and ensure that this process remains that fulfills the role of the care and treatment reviews. And the aim there, again, is get people out of hospital where there is a reasonable alternative, recognising, of course, that a lot of these assessments are going to have to be done remotely. So next, we're going to look at what happens when someone is being discharged from hospital and where it's likely they're going to be deprived of their liberty in a care home. The government has given us some guidance on the Mental Capacity Act and deprivation of liberty in the time of coronavirus. And of course, it's well worth pointing out that there are no changes at all to the Mental Capacity Act and no changes at all to DOLS. However, the guidance really seems to kind of throw up its hands and acknowledge that the backlog of DOLS cases is going to increase. This is what it's saying to care homes. If you haven't got an authorisation, as long as you're basically doing your best, the Department of Health isn't going to come down on you like a ton of bricks. But it's sort of no good news really in terms of the deprivation of liberty authorisations being done in a timely fashion. I think it's recognised that the backlog is likely to increase. And of course, also when we're looking at discharging to deprivation of liberty on the next slide, we're looking at other placements, those that aren't at care homes or hospitals, where the deprivation of liberty needs to be authorised by the Court of Protection under Section 16 of the Mental Capacity Act. Well, a couple of steps being taken to try and speed things up there. The court's accepting applications by email, and they're also accepting electronic signatures. And you can see a little bit more about that on the Court of Protection Handbook website. So last thing I want to look at really is the role of the tribunal. And Aswini has alluded to the importance of the tribunal in providing an Article 5.4 safeguard. That's echoed in the Code of Practice at paragraph 12.4, which I've set out here. It's a significant safeguard. And of course, in the current climate, it can support the effort that's being made to reduce unnecessary inpatient detention. So the tribunal during this period needs to continue to receive the information that it requires in order to make that decision. We get that information in the tribunal through reports, but also through the tribunal sometimes making directions. All the requirements in the Code of Practice about the preparation of reports, aftercare, CPA planning, they're still in force. And there's no change to the practice direction that the tribunal's issued, setting out what information it needs. Now, you may well, in preparing a case for a tribunal, be dealing with a local authority that has decided to operate the easements, but that doesn't affect the requirement at least to provide information about what might be available to that patient if they were discharged. And it seems to me that in this period, it's even more important for funding issues to be resolved. And that guidance that we looked at earlier on, I think, fortifies us if we're making that argument that it's important to try and resolve this issues as soon as possible. And the last thing that I want to look at really is thinking about fair remote hearings, and that's on the next slide. How do we ensure a fair hearing when we're having to conduct it remotely and where legal representatives aren't able to visit? I think it's right to acknowledge that a huge amount of work has gone into trying to ensure that this can be done as effectively as possible. So we know that there's a new procedure to ensure that legal representatives can get access to records by secure email. And of course, many of you will be getting used to taking instructions by phone or by video. What does one lose then? Quite apart from losing that kind of face-to-face interaction, which is often incredibly important in building trust and building confidence with the client, it's also rather harder to understand what's going on. You learn a lot, I think, by going into a hospital, seeing what's happening on the ward, getting a sense of what's going on. And obviously, of course, you won't have that when you're not able to go in. I think during the hearings themselves, I think there's a real difficulty in the loss of the sort of non-verbal communication, ability to reassure a patient during the course of the hearing. And again, of course, tribunal judges are now being seen on camera, may not always be able to see the patient, and won't always be able to judge demeanour in the same way that they do if they're in a face-to-face hearing. I, like Aswini, sit on the mental health tribunal and dealt with a case recently where I was on camera, but the patient and everybody else were on the phone, and there wasn't a camera in the hearing room, so I couldn't see what was going on. Now, in that case, the responsible clinician was kind of kind enough to explain what was going on, and that the patient was sitting very calmly throughout the hearing. So that provides some information about the demeanour, but otherwise you wouldn't always necessarily get that in the same way that you do if you're actually observing a hearing. And of course, we've got judges now sitting alone, having to manage without the expertise of either the medical member or the specialist lay member. One of the other things that's changed is communication of decisions. Prior to the hearings going remote, the expectation was that that would be communicated to the person at the end of their hearing, whether they've been discharged or not. And that's changed now, and it's now being communicated after the hearing. I would be interested to see how that is affecting people, and whether in fact they prefer to be told at the conclusion of the hearing whether they've been successful or not, or whether it's easier to get the decision a little bit later on. The very last thing I wanted to mention is, just before we go on to the diary, is a report that's come out very recently that I didn't have time to include in the slides. And that's a report called Inclusive Justice, and it's a report by the Equality and Human Rights Commission looking at remote hearings with particular reference to the criminal courts, but it's well worth having a look at. And it particularly found that video hearings impeded communication and understanding for disabled people with certain impairments, such as learning disability, autism spectrum disorders, and mental health conditions. Of course, they're very much looking at criminal cases which do take a different form to the mental health tribunal, but their key recommendation is that doing video hearings really needs to be evaluated. And I think it's absolutely right that it is this experiment is carefully evaluated at the conclusion of the pandemic period. If we can move on to the last slide now, I have given you a couple of other dates potentially for your diary. I will see now whether we've got any questions that you would like answered.
So, yes, we have 3 questions.
We certainly have, yes.
I have responded by typing answers to a couple of them, but I think we should respond to them live as well, if possible. Can you see them, Sophie?
Yes, so I've got any data being followed up about changes to the rate of the tribunal discharge, I would imagine that there will be. That data is usually collected by the Care Quality Commission, and there's no reason why it shouldn't be followed up. And I agree that I think it's important to look at that and see if there are any changes and why that's happened. So we've also got a comment about the kind of effective abolition of pre-hearing examinations, and suggestion, well, why are pre-hearing examinations not taking place, given that other assessments are taking place remotely, such as best interest assessments or MCA assessments? Well, I suppose one of the reasons is that, of course, the medical members are no longer taking part in the hearing, and for that reason, it will be quite difficult for medical members to do carry out the examination remotely, and then maybe not even be called upon to advise the judge during the course of the hearing. But it is an interesting response, and equally it's interesting that the SOADs aren't considering, I mean, SOADs at the moment are doing assessments remotely, as I understand it. That perhaps would have been an answer to the difficulties which have led to the decision to not use SOADs altogether. So maybe we could have avoided, the complete abolition of that particular safeguard. Have we got any other questions, or is there anything anyone else?
Yes, there were a couple early on. So one, we were asked, do you know when the provisions will come into force? That's the Schedule 8 provisions.
Yes.
And I said I hadn't heard anything on that. Do you know? No?
I don't, and I do want to just remind everyone as well. I think one of the comments made in the managing capacity guidance says, well, even if the provisions come into force, that doesn't mean that everyone should adopt them. They should only be adopted when absolutely necessary, in accord, for a given area. So even if they do come into force, as with the Care Act easements, not all authorities have taken the decision to operate them, and it may be that not all trusts or local areas decide to operate the Mental Health Act easements, if we can call them that, as well.
Right. I suppose that must be where they're reduced into powers rather than duties in the same way.
Yes, I mean it's different, but the guidance again is saying, don't feel that you've absolutely got to operate these easements. If you've got enough medical practitioners to have 2 recommendations rather than 1, go ahead and keep using them.
That's very much the tenor of the actual legislation, isn't it?
Yeah. Aswini, there's one other question as well I noticed about the adjournment.
We have one other question which I have already again answered in writing, which is basically relating to the postponement of tribunals. I dealt with the postponement of tribunals for CTO patients and raised the case of KB and the Mental Health Tribunal. And the question related to what the position would be for conditionally discharged patients. And there are, yes.
Yes, I mean, again, I think the practice direction allows you, if you're told that the hearing is going to be adjourned, to then make representations as to why your hearing ought to go ahead, even if the person isn't actually detained. And obviously, I think you'd be using those KB type arguments and raising concerns about the possibility of somebody not being discharged when they've got a really good chance of being absolutely discharged, or perhaps if you've got someone for whom the conditions are relatively restrictive.
I would agree. I would have certainly more concerns about the postponement of conditionally discharged patients' hearings.
Yeah.
Lovely. I think that probably deals with all the questions that we have been dealt for the moment. I don't know whether there are any other comments. I can't see any others.
No, I can't either.
If that's where we're at, then shall we just deal with the diary issues before saying thank you very much to everybody? Shall I deal with those? So there's the last slide there which sets out the diary for the next couple of weeks. We've got some more webinars coming up, and I already highlighted that we're going to do some more on emergency powers next week, and then IMCA's, RPR's housing as well by the 18th. And I think watch this space at the end. We're going to do something for Mental Health Week as well. So with that, and with the clock striking, or the digital arm reaching precisely 1600, I'm going to say thank you to everyone for joining us, and goodbye.
Bye-bye. Thank you.